Good morning and welcome. It is Sunday, May 17th, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here on a Sunday morning. We look forward to this day, and I hope that you guys do as well. Hello to Pigeon on, wait a minute, I got to read that one correctly. Pigeon Nest Tunes, good to see you. Ali Foley, just call me Kim P. Jen L. Rod says, good morning, everyone. 3 Doxies, 1 Prince. K. Dub says, good morning, Josh. Good morning, right back at you. Thank you so much, everybody who shows up on Sunday. A lot of people tell us that this is their favorite show that we do, and it's becoming, it actually is my favorite show because I really like the questions that you guys come up with and the interactiveness of the whole thing, and putting everybody on the map is such a cool. I was talking to somebody about this the other day. It is so wild, the idea that here I am sitting in our little spare bedroom slash storage room slash studio with a camera and an internet connection and literally the ability to communicate with anybody all over the world. And we get callers from all over the world. It's absolutely wild to think about the day and age that we live in. So we appreciate everybody who shows up, all of your support, all of your enthusiasm, everybody who shows up fully juiced every Sunday. Thank you so much for being here. To everyone who is new, if this is your first time watching a Sunday Fun Day, welcome. I think you're going to enjoy it. This is a good one. We've got a lot of questions. We're actually doubling up this week because I had to take some time off last week. I appreciate you guys being understanding and supportive of that. So we've had a lot of questions. Because of that, I did my best to answer all of them. A lot of them, you were all asking the sort of the same thing. So if I didn't get to your question, hopefully I answered it through someone else. But if I didn't get to your question personally, please don't be hurt. Please don't be sad. Just call us again and ask again. I try to spread the love as much as possible. To everybody who is new, let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years before I left to go into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the mission of presenting to you both sides of the courtroom, both sides of the issues, both sides of the stories. We hope that we do that. And this show is called Sunday Fun Day because it's on Sunday, and we hope we have a little fun. We take your questions that you've left us in a voice message throughout the week, and we're going to answer them live today. Stay to the end. As always, we do have some announcements, some fun stuff coming up for you. CrimeCon is quickly approaching, but in the meantime, take a deep breath. Take a deep cleansing breath. It is Sunday. You have made it. It's the end of the week or the beginning of a new one, depending on how you look at it. And we're going to have some fun. Hit that like button if you haven't already. Subscribe if you haven't already. And share this with anyone that you feel might enjoy it. All right, Ritter, here's where you shine. See if you can get it technologically under control. The first question of the day.
Hi, Josh. This is Nosy Rosie from Texas. Long-time lurker, first-time caller. I have a question that I really don't want to ask, but one that I think others may be wondering about too. We currently have 2 high-profile cases in LA. We have Nick Reiner and David. Both are capital cases and death penalty eligible. One defendant is very young, and the other may potentially raise a mental insanity defense. Does Nathan Huckman have fine line to walk given LA's racial history? Does he charge both as capital death penalty qualified cases or neither? If he declines to seek capital charges in one case, particularly the one involving a potential legitimate insanity defense, but does seek them in the other case involving allegations of a horrific crime, how much risk does Nick Hockman run of inflaming racial tensions if he does only charge David? I'm totally dating myself, but I remember the riots after Rodney King. Thank you.
Rosie from Texas, first-time caller. Thank you so much, Rosie, for calling in. Love to hear first-time callers. It always encourages me because I know that a lot of you are out there listening and watching and want to participate, and I'm glad when you finally make the jump into the deep end. And a great question, Rosie. So Rosie says, listen, you've got two high-profile cases, both eligible for the death penalty out in Los Angeles. The case against David Anthony Burke, also known as David, for the horrific murder of Celeste Rivas Hernandez. And then you've got Nick Reiner, also eligible for the death penalty for an equally horrific murder, double homicide of his parents, Rob and Michelle Reiner. And they're both death penalty eligible. And the DA in Los Angeles is a man by the name of Nathan Hochman. And he has said on both of these, though they are currently charged as special circumstance murders, meaning right now the mechanism in which to seek the death penalty is in place, but he hasn't made that decision. So he's charged both of them with first-degree murder plus a special circumstance. In David's case, it was the idea of lying in wait, financial gain, murder of a witness. In Nick Reiner's case, it's double homicide. You could make arguments, I think, for both to be worthy of the greatest punishment we have in this country, or for both to have mitigating circumstances surrounding them. I think, and I agree with you, and I think this is the way that Rosie was seeing it too, that probably the stronger argument is for David. You're talking about the murder of a young woman, first of all, that he had been committing crimes of SA against, exploiting and grooming this young woman for some time. Then when she decides to come public about it, he kills her so that he can protect his own career. I mean, if you talk about much of what the DA does is get inside the mind of the defendant. And if we're trying to decide if it's worthy of the greatest punishment we have, we want to know this is a truly evil person with truly evil, horrible intentions. I can't think of anything more clear than in this case, according to the allegations. Then you've got Nick Reiner, horrible murder, killing, stabbing, slashing, whatever it is. We don't quite know the circumstances yet. They haven't released the autopsy of both of his parents in the middle of the night. And I'm not trying to take away from the seriousness of that at all, but you've got some mitigation in the fact that he has suffered from mental illness, documented, under the treatment of doctors, given medications that may have altered his brain chemistry in a way that could have contributed to this. And historically, it's difficult for DAs to pursue the death penalty in that situation. Well, then Rosie takes it one step further and goes, okay, having done that math, what about the racial element involved? Remember, we're in Los Angeles, where sometimes racial issues can play a factor, and should, by the way. You never want to see a situation where on equal footing, people of different races are being treated differently. But I think the way we've just described this, they are not on equal footing, but people might see it in those simplistic terms. You got one person charged who's one race, another person charged who's another race, and you only pursue the death penalty against one of those races. That might not seem all that fair. The answer to a question, Rosie, is he should not take it into consideration at all. But he's also a politician, and he's also concerned with public perception, and he's also perhaps thinking about that. I would not be surprised if the conversation has been had, but I do think that they will likely make a decision on these cases based upon the facts and circumstances of the cases themselves. And we'll see. As soon as we get an answer on those, which might not come for several months, we will let you guys know and dig into all those issues again. But what a great question, Rosie. And thank you for being a first-time caller and kicking us off this morning from Texas. All right. Michelle B., thank you so much for this super chat. Says, regarding Celeste Rivas, how are they going to, or will they be able to prove if she was perhaps pregnant? As graphic and awful as this is, I don't think they will be able to prove that. I don't know. I mean, maybe perhaps they're doing some sort of testing that from her blood or something that they can determine that. I mean, her level of decomposition when they found her body was extreme. I think there's circumstantial evidence, though, that she may have been at one time, that perhaps that's what they were talking about in this text exchange that led up to the killing, as well. Maybe that happened again. But if you're asking from a scientific medical certainty, I don't know. I don't know if they're able to do, if science is able to do that with the condition that her body was in. Perhaps there's some, chemical or hormone that they're able to detect in the samples that they were able to take. If you watch the episode that we did with Joseph Scott Morgan, he talked about this. It's very fascinating. Just as a quick aside, they don't actually, she's in such an advanced state of decomposition, they don't actually take blood. There's no blood. Sure, her body is completely dried out. Again, I know this is kind of graphic for a Sunday morning, but they actually take her liver and process it in such a way that they're able to liquefy it to take samples as if, they're taking blood as samples. And that's how they were able to determine her toxicology results. And I would imagine maybe they would be able to do the same thing to determine if she was in fact pregnant, but we haven't heard anything about that. Thank you so much, Michelle, for that. Thank you, Annalie Finch, for the super sticker. Says juiced for Sunday Fun Day. We hope that you are. I certainly am. Kaylin is. Tiffany, are you juiced, hon? She's okay. She's super juiced. Sorry. And Best Nancy, thank you so much for gifting the membership this morning. Very kind of you. All right. Let's keep it rolling here. Get it together. Here we go.
Literally, happy Sunday Funday, Joshua, Tiffany, Kaylin, our fabulous mods, Cece, family and guests, Volusia K. Mayo, Humboldt, Tennessee, and I just finished this week's Sunday Funday, and I came up with my own question for this week, because I've been wondering since they said it. In the David case, there is talk about 40 terabytes, I believe it is, of data. So, can you explain how much 1 terabyte is in relation to 40 terabytes? And please do it in a way I can understand it. I don't speak tech, so if you can do it in relation to something else like pieces of paper or something like that, that'd be fabulous, Joshua. And I know really it's going to be Kaylin probably giving you that answer. So, hi, Kaylin. Now, everybody, hit that like button. And while you're there, subscribe. They're both free. And if you want to, say hi in chat. Also free. CC is fabulous. Y'all have a great Sunday Fun Day. Bye.
You heard her, AKM from Humboldt, Tennessee. Hit that like button. It's free, tax-free. Government won't know about it. Please hit that like button. I like Alicia K. Mayo because a lot of times we get people who make their call for a question right after they watched last Sunday Fun Days, and I like that. AKM does that because it's like she's the first one to get to that homework assignment for next week. And by the way, yes, Kaylin does everything for me, but I actually looked up the answer to this question myself. So there you go. 40 terabytes of information is a whole bunch of information. Here's what I was able to determine in ways that we can understand. If you enjoy watching movies, you could watch 10,000 movies in HD. That's how much information could be held in 40 terabytes. If you take a lot of pictures of your kids like I do, you could take 10 million pictures of your kids with 40 terabytes of information. Or if you just want to sit around and relax and listen to some music, you could listen to 8 million songs before you got through 40 terabytes of information. So it is a lot of information. What does that mean, though? Does that mean that they've got mountains of evidence against David? Not necessarily. First of all, I do believe they have a lot of information, a lot of evidence against David. But what is kind of skewing this to make it sound like there's more than there perhaps is a lot of this is cell phone dumps. If you think about how much information you can hold on one modern smartphone, Apple phone, that is terabytes information in and of itself. So if you're talking about he may have had multiple phones, computer devices, iPads, other things like that, cloud storage beyond what's on the phone. That starts to add up quickly, and that's where you start to get to 40 trillion bytes, which is 40 terabytes of information. But it also includes a lot of photographs that they've taken, a lot of testing that they've done, a lot of what they found on that phone, I imagine, is helpful to them. So of those 40 terabytes, there's, I'm sure, plenty of terabytes that are actually evidence. But great question, AKM from Humboldt, Tennessee, for clearing that up for all of us. I'm sure a lot of us were curious. Alicia K. Mayo, there she is, says, thanks for the ad-free lives and answering my question, Joshua. And Lord, that's a lot. That is a lot. And yes, thank you for mentioning that we do these live streams. We've dedicated ourselves to doing them uninterrupted by YouTube if you are watching us live. All right, let's keep it rolling here. Hold on. Don't get impatient. Here we go.
Hi, Josh and the CC crew. This is Jan from Driggs, Idaho, and I'm a first-time caller. I have loved Tupac Shakur and his music since I was in high school. I recently saw Tupac's family filed a wrongful death lawsuit. I'm wondering if and how this lawsuit will have any bearing on D4vd's upcoming trial. I look forward to seeing you at CrimeCon. Thanks. Bye.
Jan from Driggs, Idaho. Let's put you on the map. A first-time caller. Love it. Super juiced about that. It's funny. I thought the Tupac case would get a lot more attention from everybody, but it doesn't seem like it's one of those cases that, I mean, obviously Jan's interested in it, but I thought it would be like one of those things that would be constantly covered on the news. Here it is, a 30-year-old cold case that, if you're like myself and Jan, Tupac was very much a part of your, adolescence. And when he and Biggie were murdered, it became huge stories. And now this one at least has been solved and charged and is going to trial. And it's just kind of, people are mentioning it, following up with it. We followed it. In fact, we did a whole case notes episode about it. I think it's a fascinating story. Check it out. The murder of Tupac Shakur. We went through the entire history of what happened during the murder and what eventually led to the arrest of D4vd. But to get to Jan's question, many times in these types of cases, where there is a defendant who's got any kind of money, perhaps at all. I don't know if D4vd's got any kind of money, but their family, the Tupac family, has filed a lawsuit for wrongful death against him, which is civil, which is, first of all, a different standard of proof, right? You're talking about beyond a reasonable doubt, as opposed to preponderance of the evidence. So many times the civil suit can be successful where the criminal case may not have been. But usually what happens in these cases is that the civil case will take a back seat to let the criminal case play out. And there's a couple of reasons for that. One, they don't want to mess with the criminal case at all. They realize that that's far more important. Two, it will influence their ability to conduct discovery in the civil case if the criminal case is still pending. So if you want to take depositions of people and they're potentially witnesses who might have a Fifth Amendment issue at play, you're not going to be able to depose these people. They're going to say, I've got an ongoing criminal case. I've got a Fifth Amendment issue. I'm not answering your questions. You can depose the defendant on a civil case, but if the defendant's facing criminal charges, you can't do anything about it. You want to know a perfect example? O.J. Simpson had a civil case against him, but they waited until the criminal case was done and they deposed O.J. Simpson. There are depositions of O.J. Simpson talking about the night of the murders. Now, obviously, he's not admitting to anything, but it's on tape. And the third reason for it is that if you get a criminal conviction, it makes the life of the civil attorneys vastly easier because they mark that minute order, that abstract of judgment, they call it, as exhibit number 1 in their civil case. And they can literally say to a civil jury, this man has already been convicted of the same thing that we're accusing him of beyond a reasonable doubt. So there you go. But it won't affect the ability of the criminal case to proceed or the ability for them to put that case on, without any kind of issue being raised by the civil case. But great question, Jan from Driggs, Idaho, and thank you so much for being a first-time caller. All right. Michelle says, Ritter rocks. Can you offer ink pens as merchandise? You'd be surprised how many people take notice to ink pens. Ladies, hold on. Let me first get my merchandising department on the line. Okay. Ladies, can we do pens? I think we could do pens pretty easy. I'm getting a lot of nods saying, sure, why not? We will work on that. Thank you for that. K Dub says 40 terabytes would be like a 40-story high-rise building, for example. You would have to search every floor. That's a good point, too. 40 terabytes is a lot of information to go through. Now, I know they've got modern ability to, kind of sift through that information in a way that makes it a much more time efficient. And a lot of that, they know they don't need, right? You don't need, you're probably, when you're talking about a murder case, you're probably not all that concerned with what would be something, the weather app on his phone, but geolocation, sure. Text messages, sure. Things like that are going to take a lot of time to go through. I'll tell you, this is how old I am. Before I left the DA's office, now they hand over everything in hard drives. You literally give, say to the defense, give me as many hard drives as you can to fit 40 terabytes, and I'll hand you all the discovery. We used to do it all, burn it all onto CDs. And so I would hand over a stack of 40 CDs to the defense. But it wasn't nearly the amount of information we're talking about now because smartphones have advanced so much. But thank you, K-Dubs, for that question. And Ann Potter, thank you so much for gifting the memberships. That's very, very kind of you. All right. Where are we off to here? Here we go.
Hi, Josh. This is Marissa Seamus from Attleboro, Massachusetts. I'm a huge fan. I've been with you since the beginning. I love the show. I love all of the callers and regular commenters. Everyone's great. I'm listening to you talk about the Ethan Crumbley case and all of the cases where parents have been held accountable for their kids shooting people and killing them. And I definitely understand your argument about the slippery slope and all of that. Do you think, though, that they should be charged with anything? Because in a lot of those cases, the parents knew that their kid was mentally disturbed, mentally unstable. Definitely, it wasn't a secret. And yet they still purchased and gave the gun. I don't care if it's locked up or what. They still gave this gun to their kid. Now, I know if my kid had all of these different diagnoses, or even if not, I just knew that there was something a little off with the kid, the last thing I would be doing is buying my kid any kind of firearm. So yeah, in my opinion, because they did that, they are accountable for somebody being killed because of that. If they hadn't have given their kid the gun, yeah, maybe the kid would have found it on the black market or something. But as a high school kid, that's probably not very likely. So do you think there's any case or, in those circumstances that the parents should be held accountable? I know I'm kind of beating a dead horse here, but I'm just kind of passionate about that because I'm a teacher. And God forbid.
Oh, shoot. Well, thank you so much, Marissa, for being a teacher. And thank you for calling in and being a longtime supporter from Attleboro, Massachusetts. We're going to put you on the map. Great question. Great question. And listen, far be it from me to say that I have quick and easy answers to any of this. I agree with you, Marissa. I agree with you that I find the conduct of these parents and other parents who've been charged with similar situations, the Colt Gray comes to mind as well, is being very culpable. And should they be charged with some sort of crime? The answer, in my view, is yes. It becomes a little more difficult and nuanced when you talk about what type of crime. Should they be charged with the ultimate crime, the murder? which they have done in the case of the Crumbleys? Or should it be something less than that? And if so, why less than that? Or under what theory are we charging them? Again, I know I'm asking a lot more questions than I'm giving answers, but here's where I have the most kind of sweaty palms about this. Is much of criminal law is about putting people, the public, on notice of what is and what is not acceptable and therefore criminal legal behavior. What is it that we're putting the Crumbleys and other parents on notice of then? Okay, you say, well, guns. Well, we've also seen this extend to other situations. We've seen it extend to vehicles. We're going to talk about later on, there's a question today about e-bikes. So we're not just talking about guns because the law isn't clear on it. The law hasn't said, here's where a parent can be held responsible and here's where a parent can't be held responsible. Because we're talking about intent and negligence and criminal culpability and responsibility for another person. And I agree with you. You've got a troubled young person. You put a gun in that house, you're asking for trouble. But what if the Crumbleys had did things differently? What if they had locked up that gun and he had just broken the lock? Now, is it really the gun or is it the securing of the gun? What if they didn't know about his troubled mental state? What if he just seemed like a normal kid who one day lost it, but still had access to a gun? So is it the access to the gun or is it the mental history or is it a combination of both? When you start asking all these questions, you start getting a situation where, okay, as a parent, what do I know I'm responsible for? Well, you're responsible for being a good parent. Okay, great. Well, I've got a troubled kid. Does that mean that I've got to keep him away from my car, my gun, my e-bike, and my knives in the drawer? At what point am I absolving myself from responsibility? That's where this slippery slope stuff types starts to come in. Sorry. It's easy when you're talking about criminal liability of a couple of dudes going out and committing an armed robbery, right? It becomes far more difficult when you're talking about parents, might not be the greatest parents, but they didn't put the gun in his hand and say, go do something bad at school. That's the part that kills me, is that you still have this independent person going out and committing a crime on their own, unbeknownst to the people who've now been charged with that crime and are going to prison for it. Again, I'm not trying to say this is injustice. I'm just trying to say, okay, we got to make things a little bit clear here. But great question, Marissa, from Attleboro, Massachusetts, and we appreciate your longtime support. All right. Let's keep it rolling here. Such great questions. Here we go.
Hi, Josh. This is Ghislaine calling from St. Catharines, Ontario, Canada. First-time caller. I was just curious if you had watched the docuseries Should I Marry a Murderer on Netflix and your thoughts, particularly if the police let down the main witness. And I'm also curious if you had any experience in your past as a trial attorney or a prosecutor where you had to go into plea deals because the prime witnesses were not reliable. So that's my question, and hope you have a good Sunday. Thank you.
Ghislaine from St. Catharines, Ontario, Canada. Thank you so much for calling in. We're putting you on the map and for being a first-time caller. Again, appreciate that. I'm going to be honest with you, Ghislaine. I did not watch Should I Marry a Murderer? I meant to watch it, but I failed to do so. So forgive me for that. I do know that it's very popular. I will answer your question, but I'm not sure how it relates to this documentary. But if anybody of you have watched it and know, please feel free to weigh in. Christy Gibson says she watched it. Interesting documentary. I should give it a watch. I'll be honest. I've been so caught up and distracted with the Alec Murdaugh developments that I went back and started watching some of those documentaries and that docu-series that's on, is it Hulu? I think it's on Hulu. Fantastic. And so I started watching that again. That case was such a pivotal case to me in my kind of true crime journey that I'm just fascinated that we're going to be going through all of that again. And by the way, Sarcasm says, Joshua, please watch it. We need answers. Okay, I will do that for you. It's Alec Murdaugh. Full stop. I'm not going to hear any more debate about it because I heard them talking about it several times and everybody refers to him as Alec Murdaugh. So that's what I'm going to call him. But to your question, have I ever had to offer a plea deal because a key witness was unreliable? Many, many times. Many times. Many times you get witnesses that victims or key witnesses, eyewitnesses that come in, and part of the job of a prosecutor is to make sure of the reliability of those witnesses before you put them on the stand. I've had this situation of a witness blowing up on me. I've had this situation of not speaking to a victim thoroughly ahead of time, and then I put them on the stand in the middle of trial and just get embarrassed by what they have to say. Or a witness to a crime and get embarrassed by what they have to say. So you try to avoid that as much as possible. And when you realize that you're speaking to your victim, to your eyewitness, your key witness, the person that perhaps the entire case is hinged upon, and they are not nearly as clear to you as they appear to be in the police reports, sure, you go back to your supervisor and you go, this one is a dog. We need to do something about this. We need to settle this one because we are going to get embarrassed at trial. And by the way, it's not just about embarrassment. It's also about proof beyond a reasonable doubt. And if you don't have confidence in that witness, you should not be putting that up there just to try to see if you can fool some members of the jury. If you don't have confidence that you can prove that case beyond a reasonable doubt, you really should not be proceeding to trial on it. Great question, Ghislaine. I hope I answered that, even though I haven't watched the documentary, but now I have my homework. I appreciate the recommendations from everybody. All right. That is the correct pronunciation of Alec Murdaugh. Good, because that's what I'm going with from now on. This is the hill I will die on. All right, let's keep it rolling here. Here we go.
Hey, Josh, it's Jimmy McNutty from Torrance, California. Good talking to you, my friend. Interesting case this week. Thomas Stein. He is accused of killing a woman in a botched robbery. His co-defendant said there was 2 people in the car, but all the witnesses are saying there were 4 people in the car. Thomas, he remained silent. He lawyered up. During the trial, the prosecution had no idea who the other 2 guys were in the car. They told the jury there's only 2. But the witnesses said there were 4. So here's the kicker. Thomas Stein gets on the stand and says there were 4, and he names them. And in closing statement, the state said, now we hear these names. Like, oh, now Thomas Stein is talking. But they didn't say that. They didn't go that far in the closing statements. They didn't accuse Thomas Stein of remaining silent in his interrogation. Let's say the jury deliberated and said, well, he didn't say to the police when he was interviewed, he lawyered up. He should have told the police right then that there were 4 guys in the car.
Jimmy McNutty, we lost just the tail end, but it's a great question. First, let's put you on the map. Hold on. What did I do here? Here we go. First, let's put you on the map. Oh, I see what I did. There we go. Yes, the Thomas Stein, Torrance, California. Thank you, Jimmy. SoCal guy, one of my dudes. Appreciate you. Longtime listener. Appreciate you, my friend. Love to hear from you. You always have great questions, too. All of you do. This is the smartest community on YouTube. Haven't you heard? But this one is very nuanced, and I appreciate that, Jimmy. So let me try to break this down while I'm having these technical. What is going on? There we go. Sorry, guys. Okay, now my life is in order again. Thomas Stein, 18 years old, on trial for murder. Him and his buddy, Christopher Horn, go out and they're in a car looking to commit robberies. They're a couple of punks looking to commit armed robberies, by the way. They happen upon Kayla Rincon Miller, who's only 15 years old, along with her friends. They pop out of the car to go rob these kids, and story goes that Thomas just ends up shooting and killing her. He ends up testifying. Well, first of all, Christopher takes a deal because he's the smart one of the two knuckleheads, and he testifies against Thomas Stein. Thomas decides to take it to the very end and testify. And in his testimony, you're right, there was a lot of back and forth about how many people were in the car. The importance of that is obviously that he's trying to say, I didn't shoot, somebody else shot. You know, it's the confusion about who actually was the one who's the shooter in this situation. He's saying there's other people in the car, and here's the names of all of them. And the prosecutor gets up in closing arguments and says, well, now we hear these names for the first time. And that probably was missed by most folks, but Jimmy, because he's a smart guy, and I'm going to say because he follows Courtroom Confidential, realizes, hey, wait a minute, isn't he implying here that if this is the first time we've heard about it, that therefore he must have been silent ahead of time, and therefore is he commenting on the silence of the defendant? Well, I think, first of all, I think the prosecutors are not going to get in any kind of trouble for that. Because one, you've got a situation where the defendant is testifying, and part of his testimony is kind of like the idea of, I haven't been given a fair shake by law enforcement. But I think more than that, they have the wiggle room to say, well, we're not saying he was silent. We're just saying he never talked about this. And so they could say that if jurors are drawing the conclusion that he had refused to speak to investigators before, that would be a improper conclusion to draw, that if anything, they could just say, well, if he had spoken to investigators, he had never talked about this. But I still see the idea of how this could be sticky. But it is something where prosecutors are kind of given some latitude to talk about it when the defendant testifies, because then it does kind of become this idea, and they do this many times, where, you know, for the first time, we're hearing about this alibi. For the first time, we're hearing about other people being there. This kind of idea of, you know, isn't it convenient that it takes the defendant being on the stand for murder before the true story starts to come out? Excellent question. Excellent kind of analysis and perception. But I doubt that it's going to run into any issues. Jimmy's here. He says, finish my question. If the jury said Thomas should have said something in his interview and convicted him for remaining silent, can they appeal? If that were to come out, first of all, you got to think about the jurors are only going to talk about this if they want to. But if it were to come out that jurors had considered improperly the assumption that he had invoked his Fifth Amendment right, and therefore that was some indication of guilt, and it has to be kind of that train of logic, they could perhaps make an argument on appeal on that. But the idea of that falling into place in such a perfect storm kind of way, I think, is extremely low. But I mean, if you're asking the hypothetical question, sure, they could appeal on that. They could say the jurors improperly made an assumption based upon the closing argument that the defendant had invoked his constitutional right, and therefore that was an implicit admission of guilt. If that is articulated in a way that they can present to an appellate court, that could present problems. Great question, Jimmy. Appreciate you, my friend. Good to hear from you. All right. Michelle, thank you so much. Says, show your love and appreciation for the team at CC. Hit the like and subscribe button. Do it, everybody. Josh, thank you for acknowledging your followers. I've watched many podcasts where they don't. Oh, happy Sunday Fun Day. Of course, you guys. I'm not just sitting here alone in my room, in my spare bedroom / storage room, talking to myself, I hope. So I appreciate all of you. Thank you, Racer and Rodeo, for the super sticker. Very kind of you. All right. Where are we at here? Let's keep it rolling. See, I told you guys these were good questions this week. Here we go.
Hi, CC crew. My name is Diane. I am from San Jose, California. My first time calling in. I have a question about the new case in California, Orange County to be exact. Do you know much about the case where mom faces involuntary manslaughter after an 81-year-old man died from his injury after being struck by the woman's teen son while he was riding on an e-motorcycle? Well, happy Sunday, fun day to everyone, and happy Mother's Day. Bye.
Diane, first-time caller from San Jose, California. A lot of first-time callers this week. I love it. Let's put San Jose on the map. And this is kind of what we were talking about earlier about, this slippery slope and how far are we going to extend this criminal liability for parents. Maybe it's not just guns. Here we are, local to myself, Orange County, California. They have charged this mother, Tommi Jo Mejer, with involuntary manslaughter. And the point is charging her with a crime of child neglect. Pardon me. Child neglect, illegally allowing a child to operate a vehicle, blah, 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 plenty of misdemeanor stuff. And they've charged her with all of that. And that would be directly for her actions. But they went a step further and they charged her for her son's actions, which caused the death of an 81-year-old man who was a substitute teacher and Vietnam vet. Horrific, horrible. The DA, Todd Spitzer in Orange County, has said enough is enough. And he explains why did they charge that here. These are quotes from him. He says, we have her on body-worn camera talking about and understanding the dangers and the illegality of this particular vehicle. That is a pivotal point in all of this. She had apparently called the police herself, I think the story goes, because someone was photographing her son on the e-bike because they thought he was a little problem kid driving around too fast. That happens in my neighborhood too. Tiffany and I talk about it. We're like, what are these kids? These bikes go so fast and they're doing wheelies and they're behaving unsafely. Look at that thing. You're telling me that's a bike? Like, you're trying to say that the same kid who can ride a Schwinn should be able to get on something like that. Pretty radical stuff. She had called the police because she's like, well, people are out taking pictures of my kid. I want them to be stopped. And when they're like, okay. And by the way, lady, these bikes are incredibly dangerous. And she's on tape, the body-worn camera, saying that. He goes on to say, I'm charging the mother because she provided the motorcycle. She was aware of it. She was warned on a prior occasion that this was a dangerous vehicle, that her son could not legally possess and certainly couldn't ride it. And irrespective of these admonitions and warnings, she continued to allow him to do so. This makes it far more clear where the culpability is being drawn, in my view. Had you situations like with and again, I'm not trying to say that these were wrongly done, but I'm using them as examples with the Crumbleys of people saying to them, please don't have a gun in the home. Your son is incredibly volatile. He needs psychological help and he should not have access to any weapons. And they said, oh, okay, whatever. And still did it. Then You got no quarrel for me. This is a much more clear indication of putting someone on notice, right? There's a concept in the law called a Watson murder here in California. And it has to do with DUIs. And it has to do with the idea of a person being on notice that the consumption of alcohol and then driving of a motor vehicle is inherently dangerous and could lead to the death of another person. If you are convicted of a DUI in California, they will, at your plea, give you what's called a Watson admonition. It's based on this case, People v. Watson. They will advise you on the record of the idea that you have been, that driving a motor vehicle under the influence is dangerous and could lead to the death of another person. Why do they do that? Is that because they're wagging their finger at you? No, because they're setting you up. They are admonishing you, because if that same person goes out and commits another DUI and someone dies, they're going to charge them with murder. Why? Because they are on notice of the inherent dangerousness of that situation. They can't then claim, well, I had no idea that drinking and driving could be this dangerous. You're on notice. We've got you on tape, as it were. We've got you on a transcript. When you charge a Watson murder, they will go back and go, was that person, do we have an admonition from a prior conviction on that person? Rarely will you see a DUI charged as a murder if they don't have a prior conviction. So that's where all of this is coming from. Excellent question, Diane. First-time caller from San Jose. Appreciate you. All right. You guys juiced? Are you having a good time? I hope so. I feel like a lot of time I'm just screaming at my computer. So Lee Hillard. See this? Lee, well done. 91% juiced. I appreciate that. Thank you, Lee. Now I'm in a much better mood. Full throated motion, 53% juiced. Now my mood went back down. Wendy Joan, 68%. Not great. Intuitive Karen, 78%. Okay, at least she showed up. There we go. Therapist, you know, with a B minus average. All right. Hush up, Ritter. Get to the questions, they say. All right.
Hi, Josh and CC family. This is Tim from Melbourne, Australia again. Thanks to you and Tiff for answering my question last week and for introducing me to Greg Hartley. That was fantastic. I've since joined up as a member, and I'm also looking at merch to commemorate the occasion, perhaps a t-shirt in bloke blue. My question relates to the Brian Walshe case. I'd always wondered why after midnight on New Year's Eve was the time that Brian decided to kill his wife, Anna. I've a theory it boiled down to his entitled personality. We know he never had a real job for any length of time and felt entitled to substantially live off Anna's income. He felt entitled to steal money from his father for years. He felt entitled to defraud an art investor. Importantly, we also heard from a friend of Anna's that Anna had told her she and Brian hadn't been intimate for over a year. So the thought process of a grandiosely entitled man like Brian Walshe could well have been, if I go out of my way to host an elaborate New Year's Eve dinner party where plenty of alcohol will flow, then surely we will break our drought and Anna will owe me intimacy. It makes sense that Anna would not be interested in that because she was in a relationship with the DC real estate guy, and also because Brian is such a festering turnip of a human being. I don't think his ego and sense of entitlement could cope with that after building New Year's Eve up in his mind, so he killed her in a rage. That's my theory anyway. I understand why the prosecution didn't address this because it's effectively irrelevant for the purpose of their case, but I'd be interested in whether you had also wondered about the timing. Thanks for all that you do.
Tim from Melbourne, Australia, one of my blokes. Appreciate you, Tim. Great question. Great question a couple weeks ago, too, when we first heard from you. So thank you so much for your support, for joining our membership program. That's fantastic. We will definitely get some merch in your hands. I love this question because this is kind of what I focused on a lot when it came to the Brian Walshe case as well. I feel that there was a weakness, and I don't know if I'm using too strong a word, but I think there was of the prosecution's case, which was strong, the most difficult part for me to feel like they could establish is the premeditation of it. Obviously, he had killed her. Obviously, he had chopped her up. Obviously, he had disposed of her body. All of that, fine. But was this a premeditated murder? And yes, I'm the first one to say premeditation doesn't require, maps and charts and string and push pins, but it does require some thought put into it ahead of time. And if a murder occurs in the heat of passion, we'd call that a manslaughter. And I think this is kind of what Tim is getting at. Tim is saying, does the timing of the whole thing, the idea that they just had a party, it was a New Year's Eve party, perhaps he was expecting a different reaction from Anna that he got that evening, and one thing led to another. And I kind of tend to agree. To me, they had so much evidence after the fact of him kind of panicking and trying to figure out what to do with her body. And he's doing all these Google searches. But ahead of that, Mr. Google, the guy who's asking Google for everything, he's not asking Google anything about murder. He's not saying, what are the laws of murder? What are prisons like? How much time do you serve for murder? All of that kind of stuff ahead of time. He's talking about divorce. I think this was a marriage that was reaching a boiling point between the two of them, and that there had probably been some growing tension and animosity. I mean, we don't know, because the only two people, one of them is dead and the other one's a liar, but we don't know how tense were things. Was there constant arguments? Were they at each other's throats all the time? And on that evening, did it finally come out that she had been having this affair and wanted to leave him, and he lost it in that moment, and they got into a fight and he killed her? Or she confronted them with that, I'm leaving you, you fat art frauding scumbag, and he belts her over the head and kills her. That to me seems like a scenario that the evidence supported a little more clearly than the idea of premeditated murder. But the jury felt differently. The jury felt there was evidence of premeditation. Problem is, we will never know. The only people who could testify to that, like I said, one of them is dead, God rest her soul, and the other one is in prison for the rest of his life and not entirely a reliable source of information. Great question, Tim from Down Under, one of my blokes. Appreciate you, my friend. All right, let's keep it rolling here. Come on.
Hey, Josh and Courtroom Confidential crew. This is Ashton out in Phoenix, Arizona. Time for my about once a month call-in. This week, I am really curious about how lawyers are able to, or maybe what strategies they use to make very quick decisions on their feet in a courtroom when things are happening that they didn't expect to happen, or things are going down a path that they didn't necessarily plan for, which obviously happens all of the time. This week, we saw a good example of that during the Stefan Diggs trial, when the victim on the stand was blurting out all of these inadmissible things, and you had mentioned in your live that they very well could have made a motion for a mistrial, and the judge could have granted it, but they clearly didn't, because they felt like maybe they were winning this case, or they had a good chance at a not guilty verdict, or whatever that case may be. They made that decision, live right there in the courtroom. They didn't take some 30-minute break and go discuss it out with their co-counsel and talk about, hey, this is what I'm thinking, or are you thinking? They sort of just made that decision live right there in the courtroom. So how are they able to do that, and maybe what strategies do they use? I also just want to say how thankful I am that you allow us to interact with you in this way and interact with the community in this way. I'm not a member, but I certainly am a subscriber and watch every week. So I really appreciate being able to ask these questions and interact with the community. Everybody have a great week.
Sorry, Ashton, thank you so much. Thank you for your support and for all the kind words from Phoenix, Arizona. Appreciate you, my friend. Talking about Stefon Diggs, if you guys remember what a dumpster fire this trial was, the victim gets on the stand, and I think it was about 10 minutes into her cross-examination I think it was on the second day. I don't know if it was on the first day. But on the second day, and she's not been a good witness for the prosecution at all. She had been a little uncooperative even on direct. Then she gets on cross, and it just becomes one of these things where it's a joke. She's not answering questions. Every question she's thoroughly confused by. What color is the sky, ma'am? What do you mean by that? I'm not sure. I don't know. I don't know how to answer that. I don't understand the question. And it became abundantly obvious this person is not trying to be helpful, not trying to be honest, and probably lying, but certainly not making any friends with the jurors. Well, then at one point she's asked about her attorney's demands for money from Stefon Diggs. Fair game. Goes to motive, goes to bias. All of those things are fair game when assessing the credibility of a witness. Has your attorney asked for millions of dollars from the defendant? And she goes, it was something like, I don't remember, but he told me he'd give me $100,000 if I let this whole thing go. And she blurts out something that had obviously been litigated ahead of time. Okay. The attorneys shut it down and ask for her testimony to be stricken. And a lot of people, I'm not the only one who felt this way, felt that that was a clear opportunity to ask for a mistrial, to say, listen, Your Honor, this is a bell that cannot be unrung. You have to, you cannot instruct this away with the jury. You have to declare a mistrial here and we have to start over. But they didn't. And Ashton says, well, they didn't, and they did that quickly, and we all feel that was a very smart strategic move. How did they do that so quickly? Well, they're very good, I think. I mean, that was abundantly clear from the ways they handled this trial, even outside of that one decision. But I think it was also a very clear choice for a seasoned trial attorney to realize, no, I'm not giving this up. I've got this person on the run. They're falling apart on the stand. I'm not going to risk going through this all again. But I think your larger question is just, that is one of the ways that distinguishes really good trial attorneys from okay and bad trial attorneys, is this kind of ability to shoot from the hip and think quickly. Listen, there are many types of lawyers. There are lawyers who make a ton of money reviewing contracts and working with acquisitions and mergers and bankruptcies and everything else. And they are brilliant people who make, like I said, tons of money. But that doesn't mean you can pluck one of them and put them into a trial court. It is an entirely different practice, and it's an entirely different skill set. It is like asking somebody, asking a podiatrist to give you cardiology advice. Okay. Yeah. You all may be doctors, but there are vastly different areas of expertise. Same thing with lawyers. And so the lawyers that are trial attorneys just have this skill set to kind of think quickly, shoot from the hip, see the problems, see the chess game being played out several moves in advance so that you're not caught off guard by these things. And they did a remarkable job. And I think justice was done here by that whole thing going away. What an embarrassment for that. I'll tell you who wasn't a good attorney is the DA's office there. And I don't blame necessarily the ones who were in court. I blame that office for not just dropping this thing ahead of time. What an embarrassment. All right. Great question, though. Ashton, appreciate you. All right, let's keep it rolling. Wait a minute. What happened? Here we go.
Good morning, Joshua, Tiffany, Caitlin, ain't no hollaback girl here. Joshua, as you know, tomorrow, Friday, Brendan Banfield will be sentenced. So if you do air my question, it will be an afterthought, but I think it's still worth discussing. A week and a half ago, his defense team filed a motion with the court to set aside his guilty verdict. Just another way of saying requesting an acquittal. And they're citing that his constitutional rights were violated as his silence or by not taking the stand was used as evidence against him or misconstrued by the jury as an admission of guilt. Also, that fragments of the testimony given by his supervisor and the au pair were incorrectly considered as evidence as well. So my question to you is, can silence be considered as admissible evidence? And is it permissible in a court of law for an attorney to conclude what's in the mind of others, that being how the jury was thinking when Banfield did not take the stand? I think it's all for naught. I don't think it will fly with the judge, but I think most of it is probably just an attempt for future appeals. So yeah, that's my question. Thank you.
ANHBG from Kawartha, Ontario, Canada. Thank you so much for calling in. Always love to hear from you. Hello to our Canadian friends. Talking about Brendan Banfield. He has not been sentenced yet. It got postponed till June, just to catch everyone up on that. But this is, like I said, we talked about this a little bit earlier with Jimmy's question about commenting on the silence of a defendant. So here you have Brendan takes the stand. And this was a little more straightforward as far as commenting on his refusal to speak to investigators. And now he's speaking on the stand and drawing that comparison with the conclusion likely to be drawn from the jury that he didn't say anything because he was guilty. That's the problem. When you are implying silence is an indication of guilt, the problem is that that person may be invoking that silence based on a constitutional right, and we aren't going to allow you to use the exercise of a constitutional right as a weapon against that person. So, how is this usually handled? Well, there's two situations, and this is where the prosecution will find wiggle room here. First, post and pre, or I should say pre and post Miranda. Pre-Miranda means before that person is in any kind of custodial interrogation. They're not in custody or they're not being interrogated, right? So you haven't detained that person, but you're asking them questions. That is not custodial interrogation. Or you have detained that person, but they're freely speaking and you're not asking them questions. That's not custodial interrogation. But if they are in custody and you are asking them questions, you are in a post-Miranda situation. Okay, what I should say to go back, if it's pre-Miranda, you don't have problems with it because you're not invoking their Fifth Amendment rights at that point, right? Or rather, you don't need to worry about having advised them of it, and therefore them speaking freely can be commented on. And sometimes people do talk and then they get, well, I don't want to talk about that. You're allowed to talk about that if it's pre-Miranda, pre-custodial interrogation. But if it's post-custodial interrogation and they should have been advised of their Miranda rights and they do invoke the Fifth Amendment and remain silent, that is a hard stop, hard line rule, about as hard a line of rule as you can get in the criminal law. If you comment on their silence at that point, it is what's called Griffin error, and you are immediately talking about a new trial. We saw that recently in a case. I feel like that happened recently in a case where an officer testified and blurted out something about the defendant not speaking to them, choosing not to speak to them, and the judge had to declare a mistrial. It was a trial that happened not too long ago. Because that's how, I mean, there's no like room for interpretation for judges in this situation. There's no like, well, I'll instruct the jury on this. It is flat out Griffin error. If you don't do it, then it's going to get overturned. So those are how it usually works. But another situation where it can come up, even if you're talking about post-custodial interrogation, Miranda type situation, is if the defendant gets on the stand and makes an issue about the rush to judgment, refusal to hear my side of the story of the investigators. If they get up there and they say, you know, these guys never gave me a chance to tell my side. Now it's no holds barred. Now you can, of course, you got a chance. They had you in the interrogation room on this date. Do you remember that? And you said you didn't want to talk to them about anything. Now you're not really commenting on their constitutional rights. Now you're impeaching them, saying they never had a chance. So that's the one rare exception to that. But usually, Griffin error, bad news. Smart prosecutors won't even get like too close to the line because you don't want to appear to violate that, because a smart defense attorney is just waiting to ask for a mistrial on a situation like that. Thank you so much, Eno Hollaback Girl from Kawartha, Canada. We appreciate you. Always hearing from you. All right. Michelle B says, thank you so much. Well, we thank Michelle B. Thank you so much for supporting the mods with coffees. Appreciate that. Hippie Mimi, thank you so much for gifting the membership. Appreciate you, Hippie Mimi. Annalie Finch, coffee and tea donations for a fabulous mods. Appreciate that, Annalie. And Tiff Ritter, I think she's a member. Oh, she has been a member. Happy crewversary, Tiff Ritter. Says, can we hit 800 likes for gifted memberships? And then juiced and thumbs up. I think we can do that. Where are we at now? I can't see it on my screen here. Close? Are we close? Oh, she says we need to put a little work in. Okay, there you go. There's the challenge. While you guys are working on finding that like button, which, by the way, it's free, it's tax-free, and the government won't know about it. And it helps the algorithm is the other reason we ask for it. It's not purely a vanity thing. It actually helps other people know about the episode we're doing. I will find the next caller for us. All right, here we go.
Good evening, Josh, Tiffany, Kaylin, Mods, CC Crew, CC Pet Crew. This is Helen Scottish Llama and Teddy the Assistant's dog, or service dog, if you're in America. Here. We have a question this week that's probably something very basic, but I've never heard explained to people. And that is, you hear of law clerks in, say, the DA's office, and you also hear of lawyers clerking for judges. So what is the role of a law clerk for the judge and also in a GA's office or in the lawyer's office? Are these lawyers who have graduated law school and passed the bar, or are they waiting for, or is it in between finishing law school and passing that bar that they tend to do this? Thank you. Bye. Oh, just, and we shall not be moved.
HTSL, Helen the Scottish Llama from Edinburgh, Scotland. Thank you so much for calling in. Good to hear from you. I like this question. I think this is a great question. Again, one of these terms we kind of throw around, law clerk or clerk. What does it mean? What is their role exactly? It's kind of an amorphous term. It doesn't really, no one goes to school to become a law clerk, right? You can go to school to become a nurse and get a nurse's certificate. You can go to school, in fact, to become a paralegal and get a paralegal certificate. But there is no official kind of law clerk designation. It's just kind of generally an assistant to the attorneys who is most likely in law school. In the DA's office, they've got a team of law clerks, and they're all law students who are trying to get their way into the DA's office, get some experience, perhaps get some school credit. Sometimes they're paid. Most times they're unpaid. But then you have law clerks for judges. And these are usually attorneys, research attorneys. Sometimes they are law students, but sometimes they're full-fledged attorneys. For the Supreme Court, they have clerks that are incredibly experienced attorneys, research attorneys who've been around forever that help them put together their research and analysis, and even sometimes draft the opinions for the Supreme Court justices. And then, just to further confuse things, you have clerks in court, which are not referred to as law clerks, but a clerk of the court, who are just kind of the general assistant and running the administrative side of a courtroom for the judge, i.e. Becky Hill. That was the job she was supposed to be doing, and then she took a little bit of artistic license with her responsibilities and decided that she needed to try to convince the jurors on which way she was thinking about the case. And now we're in a whole mess because of that, which I'm here for, by the way. I'm here for the mess. I do not like the idea of justice delayed, but I am here for the mess on that one. But great question, Helen the Scottish Llama from Edinburgh, Scotland. The answer is, I don't have a clear answer for you. The answer is sometimes they're lawyers, sometimes they're not. Most of the times when you hear about a law clerk, though, it is a law student who's just kind of assisting in research and a lot of busy work, making copies, packaging up discovery. I did it. I've been, again, to age myself. Now you take all your discovery and you scan it all into a computer, and you have the computer assign a Bates number to the entire discovery. The reason it has a name of a Bates number, you might be curious. Oh, I thought I had it here to show you. Is it goes back to a device called a Bates stamp. And I think it's just the name of the company was Bates. And you used to have to take this stamp and literally stamp page by page, and it would sequentially add another number to it. So you go through and stamp physically every single page of your discovery, sometimes into the thousands, stamp, so that when you're in court, you can refer to, Your Honor, on Bates number 212 is where the defendant said, I shot and killed everybody, and I'm happy that I did it. We would like to have the court take notice of that or whatever. I used to have my old Bates stamp just because I was nostalgic and kept it. Anyhow, that's where am I going with this? Oh, that's how old I am. When I was a law clerk, that's the kind of busy work we would do, is sit there and Bates stamp stuff. But they do a lot of legal research and stuff too. Great question. All right. Move it along, Ritter. Oy vey. Here we go. Oops. Hold on.
Hello, everyone. It's Debbie again. The second case that I had thoughts on this week was the Stefon Diggs trial in Massachusetts. And there was a lot of consternation, appropriately so, about the witness not being able to answer the question that was asked. And in some cases, witnesses get dinged for this, and I don't really understand why they're getting dinged for it. This was not that case, though. I very clearly understood why this woman was getting dinged for not answering the question that was asked. As an example of this, comes from another TV show. This comes from The West Wing, as an episode in the early 2000s. One of the ones that Oliver Platt was guest starring on, he was playing a lawyer, and he was preparing CJ, the press secretary, played by the wonderful Allison Janney, for testifying in, it might have been in front of Congress, actually, I think it was, but anyway, preparing her to testify. And they were going over the concept of answering the question that's asked. And he asked her, do you know what time it is? She looks at the clock and she says, it's 12:15. There's some banter because it's Aaron Sorkin. And he asks again, no, that's not what I asked. Do you know what time it is? And she pauses and she says, yes. Love your thoughts. Have a great week. Bye.
Debbie from Arlington, Washington. Thank you so much. I love this question because it illustrates one of the real difficulties of being a trial attorney, and also where a good trial attorney can excel as far as witness preparation. Much of witness preparation is not telling the witness what to testify to at all. It's telling them how to testify. And this is a great example from The West Wing. I don't know how many of you were fans of that. She references the Stefan Diggs case, but The West Wing, I love that show. It's great. Aaron Sorkin, of course, the writer and creator behind it. And he's a fabulous writer. So that's why it was a large part why it was such a great show. Such quick, witty banter between everyone. But right. I do remember this scene, actually. Do you know what time it is? So I'm sure everybody gets that. The reason why she was wrong when she gave the time is not because she's not anticipating where he's going. It's because she's not answering the question. Do you know what time it is a yes or no question. Do you know what time it is? Yes. Okay. What time is it? It's 10:16. That's the way lawyers want things played out in court. I would try my best to explain this to witnesses so many times before they testify. Answer only the question. And it's going to take long because that's not the way we communicate. The way we communicate is to anticipate where the person we're having the dialogue with is going and help them get there quickly and share information and tidbits along the way. That is not the way we communicate in court as a witness. As a witness, it is very stilted and structured and laborious and sometimes like pulling teeth, but it's important that it's done that way. I don't know if this is the greatest example, and I never could come up with a better one, but I would always try to say, you know, the where witnesses really get into trouble is the oversharing of information. I would always say, as an example, if I were to ask you, when did you leave the house this morning? That can be answered with a simple thing, the time. But most people, when you say, when did you leave the house this morning? They go, oh my God, I could not get to bed last night. I was watching The West Wing and it kept me up all night. So then I overslept my alarm, and I usually like to make a breakfast, which is, Irish oats, and I just didn't have the time to do it. And so instead I grabbed a quick nutrition bar and then the kids were not cooperating with getting them ready. And they go on and on and on and on before they get to the idea of saying, I left the house at 7:38. The answer is I left the house at 7:38. If that attorney wants to go back and go, is that your normal time? Yes or no? Yes, no. Why were you late that morning? Well, I was late because, and then get into all of that. The best witnesses are the ones who answer just the question, and it's trying to illustrate to those people. And I don't care how long. With some witnesses, I would sit there and try to explain this to them. They would always get up there and go, well, I didn't sleep late. I didn't sleep good that night before because blah, 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 blah. And it's just, it not only does it drag things on, but it then also gives the opposing side so much ammunition to work with that they wouldn't have had before. Great question, Debbie from Arlington, Washington. Appreciate you. All right. Let's keep it rolling here. You guys having a good time? I hope so. We've been to Scotland. We've been to Canada. We've been to Australia, Phoenix, San Jose, Torrance, California. We've been all over the map with some great questions. And now I lost my place. No, I didn't. Here we go.
Hey, CC crew. It's Sarcasm from Fort Bragg, North Carolina. And y'all know that I earned my shiny armchair detective badge and a crisp and framed armchair law degree in 1994. So I am currently watching the Wisconsin versus Josie Dikeman. And there's one thing that I have a question about, because I don't think I've ever really noticed an objection to hearsay when it comes to a defendant's words. I always it always seems like everything the defendant says comes into play. You know, I kind of understand how the hearsay works with other people, but when it comes to a direct connection with the defendant, I don't recall ever seeing an objection to hearsay when it comes to what the defendant has said, texted, communicated, videoed, all of the above options. Help us out. Help me understand. Love you. Happy Sunday fun day.
Sarcasm. Love you too. Great hearing from you from Fort Bragg, North Carolina. Thank you so much for calling in, for all your support. Always great to see you in the chat. Talking about the Josie Dikeman case, not a case that I've been following all that closely, but I can answer your question about hearsay when it relates to the defendant. And you are absolutely right. Usually the defendant statements come in, but it really comes down to who's asking the question. Because the only reason a defendant statement comes in as non-hearsay, hearsay is any out-of-court statement made, offered for the truth of the matter asserted. Okay, that can apply to the defendant as well. The defendant can say something out of court, and you could be asking to have it admitted in court to prove the truth of what is being said by the defendant out of court, right? Nothing magical about the defendant, and there's no hearsay exception for the defendant. What there is a hearsay exception for a party opponent's admissions. So the party opponent, you can get their statements in. In a civil context, this is interesting because you will have a plaintiff and a defendant, and the plaintiff is a human being. So you can have the defendant asking about statements that the plaintiff made, and you can have the plaintiff asking about statements that the defendant made, but you cannot have the plaintiff asking about statements the plaintiff made or the defendant asking about statements the defendant made, because that would not be party opponent. So the reason that it works seemingly so one-sidedly in criminal court is there is only one party opponent. It's the people versus Josie Dikeman, or the people versus Stefan Diggs, or whoever. So as the prosecution, the people, the party opponent to the defendant, they can ask anything and everything about what the defendant said, but the defense can't ask it. And that might have been where you saw this hearsay objection come up. I'm curious if it was an objection made by the prosecution based upon a question lodged by the defense regarding statements made by the defendant, because then you are still dealing with hearsay. The defense would love to get up there and talk about statements that the defendant made that are favorable to them, because then that's a way of getting their client to testify without actually putting them on the stand. But it's only the prosecution that gets to ask about statements that the defendant made. One clarification, just to be specific, because lawyers like to be specific, is that if you ask for a part of what the defendant said as a prosecutor, under the rule of completeness, you might be able to, as the defense, to get, okay, well, that's part of what the defendant said, but what else did they say to clarify that statement? You know, I'm going to kill my wife. That's what the defendant said. And the defense says, well, what else did they say? They said, happy April Fool's Day, whatever. You know what you know where I'm going with this. Great question, Sarcasm. I hope that clears up what you witnessed in that case. All right. Let's keep it rolling here.
Hi, Josh and the team and everyone who's listening. This is Lynette, not the murdered one, but Lynette from Exeter, England. My question is with regards to appeals. So if you happen to testify in a trial and then it's appealed, do you have to testify again? So as in Banfield, because he made such a hash of it first time round, either they could coach him so he'd be better second time round, which seems a bit unfair, or he could actually refuse, I guess, to testify. And I just wondered how that would work if it ever came to that. Many thanks. I am always 100% juiced. Cheers. Bye.
Love that. Lynette, be like Lynette, everybody. Just running 100% juiced at all times. Lynette from Exeter, England. Thank you so much. Always great to hear from you. Great question, too. You referenced the Brendan Banfield case. What if that comes back on appeal, him having already testified? I would like to reference the Alec Murdaugh case, because that one, like I said, is top of mind for me. I'm actually surprised we didn't get a lot of questions about that one. This just blows my mind that this man is getting a new trial. And it's kind of an interesting case too, because there's a lot of circumstantial stuff going on with it. You know, where was the vehicle when? You know, they don't have any real forensic evidence. They don't have the gun. You know, there's all this motive bizarreness. I don't know. I love it that it's in the South. It's kind of this Southern Gothic feel to the whole thing. Anyhow, and with Alec Murdaugh, this question becomes incredibly poignant because he has testified and now he will get a new trial. So we're going to actually test this out. Unless he takes some plea deal, which I find highly unlikely that they're ever going to offer him anything, he may be going to trial again. So what does he do? Your first question was, does he have to testify? The answer is no. He never has to testify. But will he have to testify because he's got no other choice? I still think yes, because it comes down to he lied to investigators. He told them he was back at the house during the time of the shooting. The house is, you know, some distance away from the dog kennels where the shooting took place. And then we find this TikTok video. I think it was, no, wait a minute. Was it Snapchat? Some sort of video taken on a phone. Snapchat, yes. That puts him at the dog kennels close in time to when the murders took place. So he lied. And he's going to have to explain that. And no one can explain that but him. So unless they just want to ignore that and argue around it, he's going to have to testify. Now, what do you do if he does testify? What do you do with his old testimony? Can he get up there and change his story and say, it was self-defense? My son shot at me first, and then I shot back at him, and then my wife came out of nowhere like Rambo with a knife, and so then I shot at her. He could. I mean, nothing's legally stopping him, but they have his entire transcript from the first trial. So if he's going to testify again, which I still think he will, he's basically going to have to say the exact same thing that he did the first time around and try to pull off the same performance that he did the first time around, even though it wasn't successful. And what if he doesn't testify? Can the prosecution still get in his story? They could, but only the prosecution if they wanted to. Because again, going back to a previous question, this would be a party opponent. This would be out of court statements because they're not in this court. I know they were said in a court, but they're not in this court. Out of court statements offered for the truth. So if they want to get in without him testifying, his prior statements, his prior testimony, it's only the prosecution that would be able to bring that in. But then the defense could bring in the rest of it under completeness. Quit trailing off, Ritter. Stay on track. Anyhow, great question. Love to see how this one plays out. Hopefully this will happen within this year. If you need a happy place, join CC. That's right. Thank you, Michelle B. We appreciate you for being here. And thank you for the super sticker. That's very kind of you. All right. And MN Mom, I'm guessing that's Minnesota Mom. Thank you so much for supporting the mods with coffees. Appreciate you. All right. Here we go. Oh, see, I'm glad I looked. What am I doing?
Hi, Josh. Hi, Tiff. Caitlin, Mods, and CC crew. This is Little Miss Rover from Manchester. Note to self, research before sending your question. So it is now revised, and could you please ignore the last one? It's about the boat, the Soulmate from the Hookers case. Why was it not seized and treated as a crime scene at the start? How was it allowed to leave the Bahamas? And can the US Coast Guard only seize it when it's in international waters? Why was the dinghy not seized as well? Because that's still in the Bahamas. And lastly, if Brian Hooker is indicted, will the trial take place in the Bahamas or in the US? Thank you very much, Josh, and look forward to seeing you all on Sunday Funday. Bye.
LMRV from Manchester, England wins the award for the most efficient use of her call-in time. I loved the rapid fire of questions there from Little Miss Red Velvet. Talking about the Brian and Lynette Hooker case, situation, mystery. I don't know how you want to categorize it. It's still not categorized as a crime officially. So recently, the Coast Guard, U.S. Coast Guard, seized his boat, the Soulmate. Can we all please just, again, for another moment, appreciate the irony of that boat being called the Soulmate? And now it looks like many believe that one of the soulmates killed the other soulmate, was seized by the Coast Guard. So a lot of questions LMRV has about this. Why was it not seized before? And a lot of questions that I don't have answers to, by the way. It was seized in international waters, and I think that answers part of it, that they didn't want to get into the political, legal, international issue morass of trying to seize a boat while it was in the waters of another country. So it's in international waters. U.S. feels far more comfortable seizing it there. Seized by the Coast Guard, which is a federal agency acting in at this point in the capacity of law enforcement, but not necessarily investigating this as a crime. And I know, because another listener pointed this out, that there is an investigative arm to the Coast Guard, but I don't think that they will be the ones handling this. That investigative arm, you know, is when you've got situations like drug trafficking, human trafficking, not necessarily tasked with murders. I imagine they've handled them, but I would imagine, given that this would fall under federal jurisdiction, the FBI would get involved. Why was the dinghy not seized? Great question. I think the dinghy probably remains in the Bahamas. So again, those sticky issues when it comes to international, law. Better question is, why wasn't the dinghy attached to the main boat? Because that's where it would have stayed normally. So why is the dinghy staying there and the main boat's coming back to the U.S.? But to your last question on if there are criminal charges, it depends on who's going to charge. If the Bahamas, for whatever reason, feel that they have enough evidence, they can charge him and try them. The crime was committed in the Bahamas. If they decide not to, or they, through agreement, allow the U.S. to take over, the FBI, the U.S. Attorney's Office, would file charges based upon a crime committed against a U.S. citizen internationally. And they would handle it in some district court in the United States. And you might ask where? Well, kind of their choosing. They could do it in Florida, just based on proximity. They could do it out of whatever district his home state is out of, just out of, again, convenience. It's really up to them. The federal jurisdiction works a little bit differently than state jurisdiction. Great question, though. We'll see. I know a lot of people want some sort of conclusion on this. I will tell you, one of the things that's starting to get far more suspicious to me is that I saw an interview the other day with locals there in the Bahamas say that, listen, the way these waters work, a body doesn't just never come up. If a body is not weighed down and somebody just goes overboard and drowns, their body washes ashore. And that hasn't happened, which either means her body was weighed down or she never ended up in those waters, which I think is also a very likely scenario. Or she simply hasn't washed up. We don't know. It's a complete mystery. But great question, LMRV from Manchester, England. All right, let's keep it rolling here.
Hey, Josh, Tiff, Kaylin, fellow mods. This is Kathy. Hi, chat. Anyway, really quick question while I'm thinking about it. Should Ms. Lewis's last statements in Kouri's sentencing been reserved for her appeal? They sure sound like appeal questions to me. Anyway, looking forward to your answer. Love you all. Bye.
Kathy, thank you so much for that question. And Kathy, you must have been reading the minds of other listeners because right after you, we had a very similar question. I'm going to just play these back to back. This is from Jen from Bellevue.
Hi, Josh. This is Jen in Bellevue, Washington, and I'm listening to the Kouri Richins sentencing today. It's just a lunch break. She has not been sentenced yet. But one of her attorneys said something. Miss Lewis said that in all her years practicing, this is the first time she's had a client convicted that she believed was innocent. And I thought that defense attorneys could not proclaim your innocence if they believed you were guilty, because that would be basically kind of perjury. Or do they have a little bit more leniency to be able to defend you like that? I understand they could probably still poke holes in the prosecution's case and actions the police took and that kind of thing. But I thought that defense attorneys don't even necessarily ask their clients, like, did you do this crime? Because they don't want to necessarily know that they are for sure guilty, because it kind of restricts how they can defend them. Do I have that right? I did not want to Google that. So I'm curious what your thoughts are. Thanks again. Love watching all your live streams.
Whenever I'm on mute, the ladies lose their minds. A lot of you had questions about this. Wendy Lewis's comments during Kouri Richins' sentencing. So let's put you on the map. First of all, Kathy from New York. Always great to hear from you, Kathy. Appreciate you so much. And then Jen from Bellevue, Washington, thinking very similar thoughts about these comments from Wendy Lewis. And yeah, she gets up there. First of all, as a defense attorney, I've sat through these sentencing hearings before, and usually as a defense attorney, I don't really comment on the case at all. I usually comment on my client and who they are and why I feel that they deserve some sort of mercy or special consideration or mitigation in support of them. But I usually don't comment on the case, because what's the point? If the person's been convicted, who am I trying to convince? That train has left the station, as they say. But Wendy Lewis decides, no, she's going to take this opportunity to talk about her client. They are obviously anticipating some sort of appeal, and maybe she thought it would be a nice thing. I don't know. It's not going to be a part of the appeal. Who cares what Wendy Lewis says at the end of this? It's not like the appellate court is going to take a look at this and go, but wait a second. Her attorney says she's innocent. Hey, fellas, maybe we should take another look at this one. It really served no purpose, but probably to get a little airtime and media attention and make her client feel a little bit better that she's out there fighting for her. And she says in all her years of practice, this is the first time she's ever had an innocent client. And Jen wants to know, is that inappropriate? Kathy wants to know, shouldn't that have been reserved for appeal? First of all, yeah, it should have. It really doesn't serve any purpose here. 2, is it inappropriate? Not really. I mean, she's talking, I think, from the context of her belief in her client. she believes her client to be innocent, which maybe she does. I don't know. Maybe she looks at all the evidence and believes her client to be innocent. But then I think Jen is kind of going a step further of, what if Kouri told her I did it? Can she get up there and say, I believe my client to be innocent? That gets a little more sticky. Again, those conversations would be entirely protected by attorney-client privilege. But that still would be essentially perjurious on the part of Wendy Lewis to have your client telling you I did it, but then going out there and saying, I believe she's innocent. Many people ask this question, though, about, are lawyers allowed to ask their clients about their guilt or innocence? Of course they are. And I feel like a lot of people get a misunderstanding about the lawyer's role, a defense attorney's role. If a defense attorney is saying something like, I don't want to know, don't tell me because I can't defend you if you're telling me you did this thing, that's not a very good attorney. Okay? I'm just going to say that. As a defense attorney, I would tell my clients, I need to know everything. The last thing you want is to lie to me and I get out there and I'm caught off guard by some issue because the prosecution knows more than you think they know and you're not sharing it with me. I'm not here to cast judgment on them. They've already walked into a criminal defense attorney's office. They're probably in some trouble. And the last person who's going to start to cast judgment on them is going to be me. If I feel ethically, morally conflicted, I just won't take the case. But usually I say, listen, I need to know everything. And I'm going to go out there and try to defend you. And that doesn't mean I'm going to lie and cheat, but it's going to mean that I'm going to anticipate the potholes, the traps along the way and try to avoid them legally. But this whole idea of like, I don't know what people imagine, but the defense attorneys are like, don't tell me so it doesn't affect my ability. Go hire yourself a different lawyer. If your lawyer is telling you, I don't want to know, you open up the yellow pages again. God, talk about dating yourself. All right, here we go. Thank you to Kathy and Jen for those excellent questions.
Hi, Josh, Tiff, Kaylin, Mods, and CC crew. Happy Sunday Fun Day from Jackie in Tampa. I have a question regarding trials where the jury determines the punishment following a guilty verdict. In an unforeseen circumstance where an original deliberating juror isn't able to continue and an alternate has to do that part of the jury's duty, what happens should the alternate jurors not agree with the original juror's verdict? How does the judge handle that? I'm just curious because if I determined that one of the defendants or the defendant should not be guilty, in my opinion, of whatever the crime might be, then I would not feel comfortable working with the other jurors who decided that guilt when it comes to determining a punishment. So I was just curious, since it's a question I had while watching the Julio Foolio trial that's happening here now. Thanks so much, and I hope you guys have a great Sunday.
Jackie from Tampa, Florida. Let's put you on the map. Jackie, excellent question. Excellent question. Smartest community on YouTube, everybody. What do you do if you have a case where the jury is tasked with both the finding of guilt or innocence or not guilty and sentencing? Most likely, you see this come up most often in death penalty cases where they got to find the person guilty, and then the judge says, don't go anywhere. Great job. Take your seats. Now we're going to go into an entire penalty phase where you're going to decide whether or not that person gets the death penalty or not. And, or in some jurisdictions, they decide other kinds of sentences. So sit tight while we have you listen to this and then deliberate and come to your conclusion on that. What happens if you lose a juror in between? The answer is no. You don't just plug in a new juror and say, well, you're only going to deliberate on sentencing. You got major problems on your hands. In a death penalty scenario, what would likely happen is you would just default to life without parole, and the prosecution would just lose that opportunity. But what could happen is you declare a mistrial and start all over. You have lost a deliberating juror before the conclusion of that matter completely. And you don't get to just start all over. Now, what they could do as well as an option in the death penalty scenario is they could dismiss that entire jury and bring in, through a whole new voir dire process, another jury simply to decide the issue of the penalty. And you have seen those situations in the past too, where Nick, why am I blanking on his name? Nick, out of Florida, the school shooter. Somebody help me out here. That was only a penalty phase trial. Nicholas Cruz. Yes. Thank you for that, Helen the Scottish Llama. So you could do that. You could dismiss that entire jury, but you're right. You can't just plug people in and say, people who may have said, well, I believe this person's not guilty, having heard all the evidence, and now you want me to decide whether or not they get the death penalty. You just can't do it that way. So the more I think about it, the more I think what they would probably do is declare a mistrial on the penalty phase, continue it over to a later date, pick a brand new jury, tell that jury you're not deciding guilt or innocence. This person is guilty. Now decide the punishment, the sentence. Very good question, Jackie. That's why you just kind of hope those things don't come up, because it can cause some chaos. All right, let's keep it rolling here. We've got a few more questions. Here we go.
Hi, Josh. Hi, Courtroom Confidential. Happy Sunday Fun Day. So I missed all of you and missed you guys last Sunday. So I don't want to bombard you, sir. But I have questions. So I'm obsessed with the Hooker case. And I just picture it in my mind, here come the Coast Guard, wow, and they pull the boat over and, they get search warrants and they're going through the boat. I mean, it's fantastical, but I truly believe that boat is a crime scene. And I believe that he hurt her. And so this is phenomenal to watch this whole thing play out in real time. So I guess my questions are quite technical, so I will keep it simple. What is the Coast Guard's role? So in other words, if something comes up, the evidence is, whatever, they go arrest them. Who arrests them? The Coast Guard? And then where would that go to trial? Would they just pick a state? Would it be federal? How would that work? Because as Ashley Banfield says, TikTok, Brian, TikTok. And I justice for Lynette. That's all I can say. Her mother and her daughter are so sweet. And I want justice for Lynette. Anyway, thank you.
Sonia. Love hearing from you, Sonia. Appreciate you so much. From Chicago, Illinois. Let's put you on the map. Like I said, a lot of people curious about this new development with the Brian Lynette Hooker case, with the Coast Guard seizing that boat. And I will say it's not a small, I'm not trying to laugh this off or dismiss this as not a big deal. It's a big deal. What I mean by that is you cannot seize a person's property in the United States of America without having probable cause and getting a warrant. Well, how do you get probable cause and a warrant? There has to be some evidence. You have to have walked in front of some federal magistrate and said, here's what we know, Your Honor, and here's why we need to seize this person's personal property and take a look at it. And so there was enough there for a judge to go, sounds good to me. Go ahead and take a look. You've got enough probable cause to do that. So that doesn't mean a crime has been committed, but there's enough to get a warrant. And I'll just leave it at that. The Coast Guard being involved, I don't think we should read too much into this. Honestly, I think the Coast Guard's involved because they have boats and they seize boats all the time. And that's just kind of what they do. The FBI doesn't have a bunch of boats, right? So if you're talking about federal agencies working together, this is the Coast Guard's probably the best ones to have handled the actual logistics of taking the boat. But when it comes to the search and the collection of evidence, I imagine the FBI would be involved in that. So we'll wait to hear developments on this one. And again, if it's a federal case and it's in the US and they decide to charge, it's kind of up to them what jurisdiction they want to put it in, because it doesn't work the same way federally. They could put it into whatever district they feel is best equipped to handle this. All right. Thank you so much, Sonia. Let's keep it rolling here. Hold on. But before I do that, let me thank Best Nancy. Thank you so much for gifting the memberships. Very, very kind of you. Michelle B, thank you so much for the super chat. Says, Brian Hooker's story was too detailed to be believable. Any answer for everything rings be alarmed. How do you view his detailed answers? I agree with you. And in fact, don't take my word for it. Who was it that we had on? Was it Greg? No. Scott Rouse from the behavior panel. We had him on to talk just about this. It was a great episode. We'll find the link and I'll share it with you guys. But we had him on to analyze some of Brian Hooker's statements that he made to the media. And Scott breaks this down remarkably and notices things that I don't know how I let them slip in my head. Like things like he's being asked a question and never answers the question. You would think that would be fairly obvious to a lawyer, but I missed it. But he talks about that. This idea of kind of over detailed information is not the way the people who are recalling an event that they've actually experienced describe it. They usually talk about emotion, almost counterintuitive. But to a person who's lying, they feel that the more detail they give, the more reliable and believable they will be, but not so much to somebody like Scott Rouse. So please check that out. And thank you so much, Ali Foley, for the gifted membership. Appreciate you. Oh, we made it to 800. Oh, fantastic. Don't you got some checks to cash here, Souza, don't we? Okay. Afton, thank you so much for the gifted memberships. That's very, very kind of you. And there we go. As promised, some memberships from Courtroom Confidential. All right. Where am I here? Here we go.
Hi, I'm a newbie here, Curly Girl 211 from Fredericksburg, Virginia. And my question is, do you see a world where people give up custody, and I'm not sure what the procedure for that is, of their kids, teenagers, that they can't control, that they've tried to get help for, and they're just uncontrollable, or they're, they can't do anything with them. So that if their kid does commit a crime, they can't be held responsible for it. Is there an age limit, or is there, there's a lot of parents out there that are doing the best they can, and their child is dangerous and evil and out there doing things they shouldn't, and they have tried all kinds of things. I was just wondering, do you see this as becoming a problem for parents that are, trying to do something?
Great question, girly girl from Fredericksburg, Virginia. Let's put you on the map. Great question. Don't dismiss this scenario as entirely improbable, right? If you are a parent and you're watching the things happen where parents are being accused for letting kids drive cars, for letting kids take e-bikes, for letting kids, okay, yeah, you could say, well, access to a gun with a troubled young person, sure. Yeah, and I get that. I mean, I get why some of these cases are clearly problematic, but we're starting, because there is no clear line, we're starting to push and push and push the envelope, right? And Girly Girl says, well, perhaps one of the logical conclusions from a parent of a troubled young kid, and there are kids out there that are just uncontrollable, problematic kids, that the parents are doing the best that they can. They're worried, what if my kid goes out and does something awful? Am I going to be on the hook for it, even with my best efforts? Because what is considered best efforts? Okay, I've removed all the guns from the house. And I don't let him drive the car, and I don't let him have an e-bike. Oh, but lady, you let him have access to the kitchen knives in the kitchen, didn't you? Shouldn't you have known that this young person was troubled and would go out and stab somebody? You know what I'm saying? Maybe you're thinking I'm being ridiculous, but where's the ridiculousness there? Where's the line? Oh, I tried to get them help. And also think about this too. We're assuming a lot of parents having the resources to do this. What if you're talking about people who are just barely scraping by, working several jobs just to put that kid through school, and they don't have the resources for a therapist and interventions and around the clock monitoring of their kid? Are they just more liable? Great question, Girly Girl. I don't have the answers, everybody. Interesting stuff too. We could go around and debate for a long time. From Fredericksburg, Virginia, we appreciate you. All right, let's keep it rolling. A lot of work to do here. Not my fault. Pressing buttons.
Sup, y'all? Court Dog Daniel here. Josh, so Karen Reed has now scheduled and canceled 17 depositions. Wait, just kidding. That's not my question. I'm not touching that one. So here's my real question. It seems like really good trial lawyers know how to create the feeling of reasonable doubt, even when the underlying facts may not fully support it. One thing I notice all the time is lawyers starting the questions with the word now, like with a big pause after it. Almost like they're signaling to the jury, come on now, you know where I'm going with this. Like, now, Mr. Ritter, is it your testimony that you passed the bar in 2001? Anyway, in your opinion, how much of being a successful trial lawyer is about the psychology, cadence, and phrasing you use to shape questions versus the facts themselves? And if you want, now that you're becoming a full-time broadcaster, maybe you can give up some of your own tricks from the courtroom. 12 short days till CrimeCon. Juice!
You got me juiced, Court Dog Daniel. CDD from New Britain, Connecticut. Thank you so much. One of my dudes. I like this question. What makes a good trial lawyer? Is it more about psychology, cadence, and phrasing? I think those are hugely important. If you're asking me, are they more important than the facts? No. Even the most brilliant of lawyers can't undo some facts. But when you've got room for argument and you've got a case to be made, a really good, experienced, and skilled trial attorney, I think, can make a big difference. And we've seen that. We've watched some cases where a very experienced, good trial attorney can have an impact on a case. And yes, a lot of that has to do with kind of the stylistic presence of an attorney and the way that they ask questions. But that doesn't necessarily mean dramatic flair always. I've seen some attorneys who are very dramatic and very, big in the courtroom, taking up a lot of space with their presence, who are effective, and some who are not. I mean, we've also seen ones that we feel like need to dial it back. I've also seen, there was a prosecutor in the DA's office who was very mild-mannered. Not like, I remember many people praised him as being an incredible trial attorney. His name was John Monahan. And I went to watch him and I'm like, I don't get it. Why is this guy so good? And then I got it, having watched a trial. It was because he was so truthful that the jurors felt like they could believe anything this man said. There was no BS, no trickery with him. He was just the facts. And by the end of the trial, if that guy told them he did this crime, they believed that. But yeah, some stuff I tried to do. I was a big fan of wraparound questions, especially when you're in a sticky situation where you just kind of go, okay, so you've told us that you entered the liquor store, you had the gun in your hand, but you had no intention of using it. You walk up to the clerk, you ask them for the money, but then the clerk says, I'm going to kill you. Is that correct, sir? And then just kind of using that to further your questioning. Even on direct, you could do that. I was a big fan of that. One of my favorite things too was to draw attention to the jury as an audience in the courtroom and as the important audience in the courtroom. I would ask them, if I was really trying to grill a witness, I would say things like, are you telling this jury X, Y, and Z? Are you honestly testifying to these people, this jury, and want them to believe X, Y, and Z? And then it was almost like you were the protectors of the jury, and the jury would kind of be like, yeah, what are you trying to tell us, Mr. Whoever? I also felt that a physical presence of kind of controlling the courtroom was important. I would approach a witness whenever possible, never stay just behind the podium. I would demonstrate things physically whenever possible. I even psychologically, whenever I would go grab the podium, I would move the podium. It was like I wanted people to understand they're in my house and I move the furniture as I see fit. And I don't know if that worked or if it just gave me a psychological edge or if it actually had a subconscious effect on the jury. But I just wanted them to know I was very comfortable and this was my space and where I'm kind of in control here. So a lot of that, can be taught. Some of it can't. But I think it does have a cumulative effect of being more effective. But thank you, Court Dog Daniel. Thank you for always running Super Juiced. And thank you for reminding us of CrimeCon quickly approaching. All right, let's keep it rolling here.
Hey, Josh, Tiff, Kaylin, CC crew. This is Allie Foley from Norman, Oklahoma. I'm calling in with a question on AI. I know it's a fun topic these days. A couple weeks ago, you had spoken about using AI in the courtroom, but my question has to do with using AI when you're preparing for cases, when you're writing your briefs and responses. The SDNY actually ruled a couple weeks ago that any AI generated work, so those briefs, responses, and other things, are actually not privileged or covered by the work product doctrine. With many places using AI now, especially when sifting through thousands of pages of discovery, what impacts do you think it'll have on other cases throughout the country? And I'd love to get your take on whether or not you agree or not with the ruling. Thank you again, and I love your show. Have a good one.
Allie from Norman, Oklahoma, thank you so much. Let's put you on the map. The quick answer, what effect is AI going to have on the law is, I think it's going to have a far more profound effect on the law than we anticipate. And I think it's going to have a far more profound effect on everything than we anticipate. I mean, it is remarkable what AI has done as it's become a consumer product in the short time that we've been familiar with it. And it's remarkable how we're starting to see it integrated into more and more stuff. I mean, it's like every company now, it seems like, has an AI tool. I'm starting to use AI way more than I thought I would. And it's incredibly, incredibly powerful and time-saving and labor-saving. I mean, the stuff that you can get it to do, which would have taken you traditionally hours, and it can do in a matter of seconds, is mind-blowing. And I know a lot of lawyers. In fact, lawyers are promoting their use of it. It can be a very valuable tool for going through discovery, for analyzing arguments. But I think where the law runs into a problem is when you don't give it that final human review. And that's where we've seen issues, where people have allowed AI to write a brief and then don't cite check the citations in that brief or read through the arguments. And that's just laziness. I mean, those same attorneys, by the way, before AI, were having law clerks write their motions and not reviewing them and sending them out. Okay. So lazy attorneys are going to be lazy attorneys. But I think you could use AI to have it do amazing stuff for the law, as long as you double check and make sure that a human being is still behind all of it. But you're right. Interestingly, in a case, U.S. versus Hepner, this was out of the Southern District of New York just this year, they ruled that written interactions between a criminal defendant and a generative AI chatbot are not protected by attorney-client privilege or the work product doctrine. So this is stuff we're going to have to establish. So what, in that case, it was a defendant was using AI as almost as their attorney. And they're saying that, no, not only does that not qualify for attorney-client privilege, it also doesn't qualify for attorney work product, because we're not going to consider the AI's responses and work as work product. Well, that's when the defendant's asking. What if when the attorney is asking AI to do something, does that remain attorney work product? I kind of think it would, because the attorney is using this tool in that sense. But again, questions that are just going to have to be answered. All right. Great question. Allie from Norman, Oklahoma. Let's keep it rolling.
Hiya there, CC crew. Happy Sunday Fun Day. This is Jules from Waterford, Connecticut, and I'm coming in with another question from the CC Live Trials group chat. This is with regards to the Kouri Richins trial and the various letters and statements of support she received. Some of them made sense to us, such as family members and jail volunteers expressing their support of her. But others were quite surprising and unexpected, to say the least, such as from the defense team itself, as well as from those who don't know her personally. One example of this was someone who spoke on her experience of her father murdering her mother when she was a child, and another example was a mother whose son was murdered as well. So our question is, how common is this practice? Is it fairly standard? Are these kind of folks approached to give these support statements, or do they proactively reach out and volunteer to do so? Could it even be a mix of both? We appreciate your thoughts. Thanks so much.
Jules from Waterford, Connecticut. Let's go ahead and put you on the map. First off, thank you so much, Jules, for calling in. And then I also want to give a little shout out and credit to Nishay from Pennsylvania, who asked a very similar question on this. A lot of you had questions on this. Like I said, we had a lot of questions this week because it was a couple. I took last week off. And so I was trying to do best to get representative questions of things that a lot of you were curious of. So again, thank you to Jules. Thank you to Nishay. Again, going back to Kouri Richins and some of the interesting developments that took place during her sentencing. We talked a little bit about what her attorney had to say, but there were also letters presented in her support from people unconnected to the case, just talking about their experience with, loved ones having been killed by a spouse. To your question, Jules, is this common? No, not at all. In fact, I have never experienced it. I'm actually surprised the judge allowed it. I could see if the prosecution, if I were the prosecutor aware that they just wanted to bring in letters from random people in support, I'd be like, what is this? The court shouldn't, okay, great. I could go out and find a bunch of letters of people who say, we want her burned at the stake. That should have no bearing on the proceedings here. This should be from victim impact and defense mitigation people who know and love her, but not outside people. I think the judge, I got no problems with this judge, whatever, Judge Mrazek. I think he just was kind of like, okay, whatever. Let's just get through this. I mean, I've already made my decision. Nothing is going to persuade me otherwise. I'm basing my decision on what a psychopath you've been. If you want to bring in some other people to say some nice things, as long as it doesn't take a bunch of my court time, go for it. But it was bizarre. So thank you for that question. All right. Oh boy. Here we are. Get out the waterworks. It is the final three, everybody. We went a little bit long today. Like I said, I tried to include more questions than I usually do. Here we go. Bringing us home.
Happy Sunday Fun Day, Josh and Courtroom Confidential. This is Court Lurker calling from Spokane, Washington. I also want to say hello to all of the mods and Tiffany, sweet Tiffany, and Kaylin, and everyone else. I had a question, and I hope it's not a dumb question, but it is. I'm watching a trial right now, and I just heard the state object to something being played because it was prejudicial. And I've heard that like lots of times, but mainly from the defense. So I don't know if I'm just not remembering any trials. I've watched so many trials. Oh my goodness, so many trials, so many cases, so much true crime. I don't really recall hearing the state objecting to something being prejudicial. Is that a rare thing, or am I misremembering? I'm so sorry if I am, and I'm sorry if this is such a dumb question, but I'm just, how rare is that? And I want to wish everybody a happy Sunday Fun Day, and I will see you all in
Court Lurker from Spokane, Washington. It's not a dumb question. It's a great question. I love these questions. I love these types of questions that are like, I'm sure something a lot of us have been curious about. Let's go ahead and ask it and educate ourselves a little bit. First of all, there is, of course, the state can lodge a question or an objection for something being prejudicial. Sure, it can be prejudicial against the state. Is it rare? It's probably more rare because of kind of the thought process you went through, Court Lurker, that usually when we're talking about evidence, we're wondering about that evidence effect on the defendant. Is it more prejudicial or probative to the defendant? Rarely are we considering how that might affect the government. But you can have stuff that's prejudicial to the victim. You might say, hey, this is, I'm objecting as what is about to be said is simply prejudicial to the victim and has no probative value. It could also be prejudicial just generally to the jurors' emotions and reaction that has nothing to do with the case. What I mean is, what if you brought up a certain political issue or something that was in the news? I had a defense attorney one time that cited in his closing arguments to some statistics in the LA Times about wrongful convictions. And I'm like, come on, Your Honor, this is, what are we doing here? Now that I could have objected as prejudicial. I think where you see it more often is the objection probably that should be made is relevance. There's no relevance as to the LA Times article. There's no relevance as to the sexual history of the victim. There's no relevance as to what this person is about to testify to. I think you probably see it more often as that type of objection than prejudicial, but doesn't mean it can't be lodged by the prosecution. Great question. See, not silly at all. Great question. All right, let's keep it rolling here.
Hi, Josh, Tiff, and mods. This is SheFly999, often a lurker, rarely a commenter, first-time caller. My question is regarding the appellate process. I know most defendants usually hire new counsel as their appellate attorneys, and I was just wondering, why is it that the original attorneys aren't more involved in the appellate process? Often the arguments that are made and things that are debated during an appellate argument involve arguments that the original attorneys made. And I was just curious as to why they're not more involved in that process and why the appellate attorney is just kind of left to argue on their own and suppose what the original attorney was meaning or not meaning by arguing whatever it is, or they didn't argue in the original trial. Thank you so much. Happy Sunday Fun Day.
Happy Sunday Fun Day, right back at you, SheFly. Great question. I'm so happy that you're a first-time caller. Only problem was you didn't tell us where you're from. So we are guessing you are from the planet Earth, and therefore we've tagged the entire planet. But thank you so much. Please let us know next time. Would love to put you on the map. And it's a great question. And I kind of got into this a little bit earlier about how specialized the practice of law can be. Why are the trial attorneys not involved in the, let me say this first. A lot of criminal attorneys do handle both. A lot will have an appellate practice. Some will do that. I worked at a law firm where we had one person there who was kind of an appellate specialist that worked in the firm. So we would keep a lot of these appeals in-house. But the vast majority of criminal defense attorneys do not practice appellate work because it is an entirely different way of practicing. You don't have your podiatrist consult with your cardiologist, okay? That is like how vastly different a lot of these practices of law can be. You know, the same goes for talking to a civil attorney about criminal issues. You know, you don't, a lot of people just call up any lawyer that they happen to be familiar with when they've got a legal question. I get those questions all the time. You know, I'll get a call from someone saying, you know, with some sort of probate issue, and I'm not your guy. If you'd be asking me, I'd be asking you to try to recall that class that I didn't do all that well in back in law school forever years ago. The practice of law is very specialized. So that's why most trial attorneys are not involved in the appellate process. And the other answer to that is sometimes they do involve the trial attorney because there might be some sort of particular issue that they need walking through. And the other reason is sometimes they don't because they want to make an ineffective assistance of counsel argument. So maybe they're throwing that trial attorney under the bus, and it's probably best that they don't include them in on that journey. Anyhow, great question, SheFly. Appreciate you asking. All right. Bringing us home with the last question of the week is something a little bit special. We received a letter from Roberta from Oklahoma way back several months ago. Roberta is a faithful listener and follower of Courtroom Confidential, but Roberta admits that she is not all that technologically advanced, but she didn't want that to stop her. So she's reached out again with a question and some thoughts, and we wanted to share that with you. This is from Roberta. Roberta hand wrote us a letter and then took a picture and sent it to us. And I'm going to read that to you in full. She says, "Good morning, crew. You may or may not remember me from last year. I had pneumonia turned to double pneumonia. My God. One great thing from all of it is I had a lot of time to get addicted to your show as well as others. So much that my husband, Ron, and I will be celebrating our 40th wedding anniversary with y'all. We're going to Vegas, baby, straight to CrimeCon. I love this. First of all, happy 40th. That's incredible to you and Ron. And I can't wait to meet you at CrimeCon. This is great. I've got 2 ideas for possible killers for Miss Nancy Guthrie. I'm here for it. 1, Sheriff Nanos wanted to become famous and improve his hated image. What better way to do that than to take an 84-year-old woman from her own for a couple of days, only to be the knight in shining armor and rescue her. I think Savannah will be more than thrilled to publicly thank Nanos for finding and saving her mom. Well, if true, he's taking his sweet time doing that. And 2, seasoned Pima County law enforcement got so fed up with his crap that they just one took Miss Nancy, knowing sheriff would fail to find her because he either fired or placed great folks into less than deserving jobs, such as an experienced Sergeant Aaron Cross answering phones. Many retired or left that department. Who better to pull off this than older cops with experience, definitely wise enough to pull it off, just so the sheriff would be so embarrassed, so humiliated, he and his goonies would fail. I'm just being devil's advocate. With either scenario, something went terribly, awfully wrong. Can't wait to meet y'all. Thanks for reading. Perhaps I could get some help in getting on YouTube to become a first-time member to any show. I can't even figure out how to order a shirt to get in time to wear for my first day there. Oklahoma Mima, Roberta and Ron, you show up at the Courtroom Confidential booth and we will get you covered on a shirt, and we will make sure that you figure out how to make that happen. And we would love to have you as a part of the crew. Thank you so much. This is so sweet. I love this. We'll hook you up, Mima and Ron. I love that Ron's coming too. And happy 40th anniversary again too. Listen, are those theories wild, Roberta? Of course they are. But who knows at this point? At this point, I think anything is still on the table. I mean, this is so horrific to me that we are how many months out now? This happened in the beginning of February, and we're now midway through May, and they still have not found this poor woman or located the person who took her. So did somebody from law enforcement do it? Who knows? Who knows? And and the problem is, I don't think they know either. And that's the real problem here. So I agree with you. A lot of frustration, and deservedly so, thrown at Sheriff Nanos. And speaking of CrimeCon, Roberta, why don't you and Ron join us at the panel that I will be speaking at with my co-hosts, Paul Moreau and Donna Rotuno from the Weekly Rap Sheet, alongside Mike Ruiz from Fox Digital. We're going to be talking all about Nancy Guthrie and where the case has been, where it's going now, at our panel at CrimeCon on, what is it, Friday at 3. Oh, look at that. I even got the day and time right. So we would love to have you there, cheering us along the way. All right, guys, let me give you some quick announcements and get you all out of here. First of all, go to thecourtroomconfidential.com for the big 3 M's. If you loved the messages this week, but you didn't get your question answered, how do you leave us a message? How do you participate? You go to thecourtroomconfidential.com and click on leave us a message, and then we will answer your question at the next Sunday Fun Day. Memberships. A lot of you received gifted memberships. Thank you to everybody who gifted one. If you didn't receive one, don't despair. You can join up yourself at thecourtroomconfidential.com by clicking on join, become a member, and join the CC crew. And then finally, merch. If you have been so blinded by how much you love this shirt that I'm wearing today, and you say, I can't wait to get one of those, or plenty of the other products that we have available. Kathy Mama Bear says it's Princess Purple Perjury. My girls would love that. Hearsay Hyacinth. Am I saying that right? Hyacinth. That is going on my vocabulary list. Blue Bear says, I like your lilac t-shirt today. Get it, everybody. Inspired by Tim says Emerald's Child. Josh's shirt color, Bloke Berry. Love that. Bloke Berry. There you go, Tim. We've got these shirts. We've got plenty of colors available. We've got mugs, and we've got tumblers, and we've got notebooks, and we've got hats, and we've got zip up hoodies and quarter zips and pajama pants, and we've got you covered. And we've got a bunch of new summer stuff coming out soon. So stay tuned at thecourtroomconfidential.com on the shop. Love to outfit you all. All right. What did you miss this week? Well, on Friday, we had the weekly roundup. We talked about the Murdaugh case and the Kouri Richins case and the Shanna Gardner case and plenty of other stuff. So please check out that episode. Really proud of it. It's up on the channel now. As I mentioned, the weekly rap sheet on Fox Nation is now available for you. The latest episode, we talked about a lot of these same cases, but you get, three attorneys for the price of one talking about these cases with Fox, with Paul Morrow and Donna Rotuno. Please follow us on our new social media at Weekly Rap Sheet, both on Instagram and X, where you can leave us questions. And we did answer some of your questions. And I will say that the Courtroom Confidential crew members are becoming known as asking the best questions for Fox Nation Weekly Rap Sheet. That was an internal discussion that we had. And another reason why you can join up to Fox Nation, if you're saying to yourself, do I really have to join another streaming service? No, you don't, but we would like you to. And if you do, we'll get you 50% off when you use the code CrimeCon2026. 50% off an annual membership. And what you get with that is, one, access to everything on Fox Nation. There's a ton of stuff out there, including the weekly rap sheet and all of our episodes. And Fox Nation is the exclusive streaming service for CrimeCon. So if you're not able to make it to CrimeCon in person, you can watch it streamed live on your whatever device you use, but go to Fox Nation to stream it live. And you can also wear your Courtroom Confidential t-shirt while you're watching it. So it's like you're at CrimeCon, because we have been smart enough to make all of our t-shirts wearable both inside and outside. They're both inside-outside t-shirts. So we've got a CrimeCon branded t-shirt available in a couple of colors, along with everything that we just all talked to you about. So please check that out. Thank you so much, The Crafty Ariane, for gifting that membership. Appreciate you. All right. Thank you so much to K-Dubs. Can a pillow with Josh's face on it like the Keith Morrison pillow? No. I'm going to say a big old no to that. The girls both look incredibly excited by this idea, and I can tell that they're going to try to convince me of this, and I'm already going to say no. What did you miss? Or pardon me, what is coming up this week? Well, on Monday, on our sister channel, Courtroom Confidential Live Trials, we will be streaming the Ebony Parker trial. So please go check that out. It's scheduled to last through that week. It is, I think it's going to start tomorrow morning with opening statements, or tomorrow afternoon with opening statements. So if you haven't already, please subscribe to that other channel of ours, Courtroom Confidential Live Trials, for all of your streaming needs. Also on Monday, we're back here again with our Monday night special, live at 5 p.m. Pacific, 8 p.m. Eastern. And then we're back again Wednesday for, by the way, Wednesday's going to have a different time. So this is why you stay to the end for announcements. We're going to be going live at 3 p.m. Pacific instead of 5, so a little earlier, 6 p.m. Eastern. And we have a very special guest that we would like to announce for you. On that day will be somebody you may have heard of, Vinnie Politan. Vinnie Politan, by the way, always fully juiced. So we look forward to speaking with him on Wednesday, 3 p.m. Pacific, 6 p.m. Eastern. And then finally, like I said, it's just 2 weeks away, CrimeCon, May 29th through 31st in Vegas. 1-day passes are still available. Use the discount code Courtroom, all caps, all one word, for 10% off at checkout. We've got our shirt available now to everybody. Very proud of this shirt. Do you guys know, by the way, that Kaylin designed this shirt? Isn't that incredible? That's all out of her head. She's amazing. Please pick up one before you go to CrimeCon, whether you're watching it on Fox Nation or watching it in person. Like I said, I'll be on a panel with my co-host for Talking Nancy Guthrie. That's on Friday. And because you all are amazing people, you've made it possible for us to be nominated for a Clue Award that year, which is the People's Choice Award for Creator of the Year. Thank you from the bottom of our hearts. We are so honored to be a part of this exclusive group of people. Nancy Grace, Annie Elise, Crime Weekly, the prosecutors, they're all pardon me, they're all nominated as well. We wish them all the best, but honestly, I know people say this, we are just incredibly honored to have been nominated. So please, if you feel so inclined to vote for us when you get to CrimeCon, we would appreciate that. All right. Last people I would want to thank is our incredible. Oh, thank you to Emery Rue for becoming a member. Be like Emery Rue, everybody, and join up at thecourtroomconfidential.com. But to the best mod squad on YouTube, I think we can all agree, without question, is Afton, Sonia, Kathy, therapist you know, and Best Nancy. Thank you so much for everything that you guys do and for making everybody just have such a great time here. Kaylin, who does everything, except I did research that one question today, Kaylin. I do want a little bit of credit for the 40 terabytes thing. I did that all on my lonesome. Kaylin, you're the best. Tiffany, you are the best thing that ever happened to me. We will see you all here tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern. Take care, everybody. Bye-bye.